Want to thank Senator Wiener for bringing this forward. I know obviously we've been working on companion legislation related to this issue. Obviously, this has become a huge topic of concern because of what is happening with federal immigration enforcement officers in our communities. And it has created so much fear and so much harm and so much chaos. You've heard me talk about it before, and we did an adjourn in memory for him, but Roberto Carlos Montoya Valdez was killed just a month ago when running from ICE agents in the city of Monrovia. He was a Monrovia resident and a day laborer, and he is no longer here. His family no longer has a father because, you know, he was running away in fear. And this is a man that had no criminal record, no criminal history. And so we see these things happening in our communities, and you know, I think for us as state legislators, we're trying to figure out how to respond. Before I got elected to office, I didn't anticipate that I was suddenly going to be in a fight with the federal government, and we would suddenly be in this middle of constitutional crisis, and it has certainly thrown, I think, all of us for a loop. With that being said, I do know, and I've heard very clearly from our local law enforcement some of their concerns. And I want to ask particularly about the immunity piece, because what's been shared with me is that the immunity piece that's now been added into the bill is actually reflected in previous legislation that was brought forward before. And I wanted to see, is that true? Is that the case? I recognize that the topic of local law enforcement and immunity is a hot one. It is certainly one that I know that's happened up in this legislature previously and times before I've gotten here. And I know that it's certainly, you know, a topic of concern, particularly for local law enforcement. So wanted to understand if you know whether or not that's been reflected in previous legislation that's not been successful.
Thank you, Senator Perez. So there are limited immunities available to peace officers, and those have been amended over time. I think what you may be referring to is SB 2, which eliminated many of the immunities that peace officers previously had. There's also Government Code Section 820.4. The California Supreme Court has also interpreted this, limiting when immunity is available. It doesn't eliminate their defenses. I think much of what has been raised here is a concern that they will do something innocent in an effort to protect their health or safety, and that they will be brought up or sued by an individual. They still have a good faith defense to that, and any other defense they choose to bring forward in those moments to explain why they wore the mask and that they believed it fell within their policy. What we're eliminating here is the ability to claim qualified immunity when you, one, assault somebody, batter that person, falsely arrest them, falsely imprison them, abuse the process, or maliciously prosecute them, and that you do one of those 6 things while you're wearing a mask, and that you're wearing that mask willfully and knowingly. So it is many steps of a process that have to be taken in which the individual would then not receive immunity. Which, be clear, immunity means that we as the taxpayers are paying for a person to willfully, knowingly wear a mask and assault us. So that is the circumstance that is prohibited. Intentional, reckless violations of the law that aren't reasonable are not protected by immunity currently. If an officer walks out on the street while he's patrolling, as we saw the ICE agents, and shoots at a car without provocation, without reason, that's not going to be covered by immunity. So this is similar in that we're saying acts that fall outside of the reasonable enforcement of the law that are currently torts, the list that we have taken, those 6 that I mentioned to you, are already in the Federal Tort Claims Act. We lifted it directly from there. Those are torts that the federal agencies can be found to violate also as personal liability.
Mr. Feldman.
Yeah, I'm going to defer to my legal colleague next to me, but I will say the immunity provisions in SB 2 were rejected by the Senate. When that was proposed, they did not go through. But I'll let Dave explain.
Thank you, Senator. That's a great question, and that's one of our primary concerns for local law enforcement. The good faith defense is nowhere in this bill. It's actually stripped from the bill. It's the exact opposite of what was just said. The immunities are very minor, basic immunities. They are what provide the good faith defense. things like if you make an arrest and there's a technical defect in a subpoena, you can't then sue the officer for false arrest if they believed in good faith that that subpoena was valid, just as an example. What this bill does is it strips away that officer's ability to assert that defense if they intentionally wear a mask, and even if they believed in good faith that they fell within one of the exceptions, they would lose all of those immunities. And so it's really setting it on its head, talking about good faith in this way. Laws, general laws mean that you intended to do the act that's prohibited, not that you intended to violate the law. You've all heard the phrase, ignorance of the law is no defense, unless it's a specific intent crime, which this is not, where you specifically intend to violate the law. This bill says if you specifically intend to wear a mask, and then it turns out that you were not permitted to wear a mask because you didn't fall within one of these exceptions. For example, it says only particularized concerns for safety would fall within the exception. Generalized concerns don't. So if an officer is exposed to a methamphetamine lab that they didn't expect, and that doesn't fall within these definitions, and it's not regular safety gear, and they just use a scarf or something to cover their face, they would technically be in violation. If they arrested somebody and it turned out that there was a technical defect in that subpoena or that warrant, they would then lose all of these immunities, which are just baseline, like that if you're acting in good faith, if you reasonably believe this was the person that you arrested, if you reasonably believed that this was a valid prosecution, it's stripping all those away, and it's saying now, if you wear a mask and you weren't allowed to, then you're held to strict liability for all of these types of claims. And then it incentivizes lawyers to sue officers by having a $10,000 statutory damage, even if there's no actual harm to the person. And the frustrating part for my clients is that it is very clear that this law is an easy win for the Trump administration. It's not going to be applied to federal officers. It's going to land on your local officers who have nothing to do with this fight and already don't enforce immigration bills. This is an easy win for the federal government under immunity and under preemption.
Thank you.